Good afternoon, everyone, and welcome once again to NCBI's Advocacy Talks. My name is Liz Jeffrey. I'm NCBI's Advocacy Officer. We're delighted this month to welcome AnnMarie O'Boyle from the Office of the Ombudsman. AnnMarie is an investigator with the Ombudsman, and today she's going to tell us all about the role of the Ombudsman and how you can make use of the Ombudsman services. Over to you, AnnMarie.
Hi, hello everybody. Sorry for last week's hiccups. Yeah, just a quick talk about what our office does and how we may be of benefit to people. Just a quick presentation, but we're always available to answer any questions. I'm very conscious when I'm talking to any group of people with disabilities that our office is relevant in terms of specific issues related to disability. So maybe disability services, disability allowance, social welfare payments, but also anyone who complains to us about anything may have a disability. Agriculture, revenue, anything. I'll go into kind of what we do later so that will make a bit more sense. We don't actually gather statistics, but just it's something that we are mindful of. So I'll just go on and start here now, an overview. So what we do, what type of complaints do we deal with, how to complain, complaint statistics, case studies, and then questions. I think that'll be mainly from Liz. So who is the Ombudsman? The Ombudsman is Ger Deering. Ger has been the Ombudsman since 2022 to today. He was previously the Ombudsman for Financial Services and Pensions, and we've been lucky to have him to come over to us. Ger has been really interested in disability, and actually in this year ran a group for various advocacy bodies and other NGOs related to disability to try canvass what they felt might be current issues within the sector. So he does have a particular interest. What we do, sorry, I lost myself, gone backwards. So the Ombudsman, the Office of the Ombudsman was set up in 1980, and we investigate complaints from people who have been unfairly treated by a provider of a public service. We deal with almost all organisations that deliver public services. We can investigate any action taken on or behalf of a reviewable agency in the performance of administrative functions if that action has or may have resulted in adverse effect. So essentially, the reason we say provider of a public service is in the past, we traditionally just dealt with, say, Department of Health, the HSE, but our remit has expanded. So now we actually also cover private nursing homes. So although they're a private service, because of Fair Deal, I think all but one in the country receive funding from public, funding of public services through Fair Deal or the Nursing Home Support Scheme. So that's how they fall under our remit. So that's why we say provider of a public service as opposed to just a public service. When we're looking at a complaint, there has to be an adverse effect. So just because something went wrong, if there's no kind of poor effect on the person or you're not affected in some way, then we wouldn't look at it. And the other thing is that it has to be an administrative function. So something like clinical judgment, we wouldn't be able to look at. When we get a complaint, we identify if there's maladministration and adverse effect, and what we're usually looking at is whether something's gone wrong, what needs to happen to prevent it happening again, ensure learning and prevent reoccurrence, and generally we would ask for an acknowledgement of what went wrong to the person affected and an apology. So we deal with both individual complaints from individuals, and the Ombudsman under the legislation also has the power to initiate systemic investigations. And if you look on our website, you'll see we've done a few in relation to the Magdalen laundries, in relation to social welfare overpayments. I would have led the investigation into people under 65 in nursing homes. We've done one recently on the cross-border and treatment abroad scheme. We're doing one at the moment into the HAP housing scheme. So we have that power to kind of look at some broader issues. Who we can take complaints about, and it's probably within remit, government departments, offices, local authorities, health and social care, as I said before, nursing homes, both private and public. education, regulatory bodies, direct provision and other sectors. So pretty broad range, to be honest. Department of Social Welfare, hospitals, nursing homes, TUSLA, Department of Agriculture, Revenue, really broad, broad span. And then I think it's helpful to know what we can't look at. So the Gardaí are not within remit. GSOC would be the relevant body who deals with complaints about the Gardaí. Defence Forces, similarly, they'd have their own ombudsman. Immigration, naturalisation, pensions and financial services, again, they'd have their own ombudsman. Children, that would be the Ombudsman for Children. Prisons, we can't currently look at, but that should be coming in remit in the not so distant future. Employment or consumer issues, press, which have their own ombudsman, and utilities. So as I said, there's the Garda Ombudsman, the Press Council of Ireland, the Ombudsman for Children, Financial Services and Pensions Ombudsman, and information on all of them should be available on the internet. So we also have particular powers under the legislation to deal with complaints about the Disability Act 2005. And this involves complaints about access to public buildings, services, information heritage sites, accessibilities of services supplied to a public body, and compliance with measures set out in sector plans. We don't have a role in relation to public service appointment. The Equal Status Act, various acts would deal with that. But if you've complained that you feel there's been non-compliance with the Disability Act, then you can come to us. We actually, interestingly, have a relatively low number of those complaints. So if you have any queries, please do feel free to come to us. But generally, what we're looking at is compliance with the Act. The Ombudsman is impartial, so we're not an advocacy body. We would not be on advocating for someone. We would not be on the side of the body either. We're completely independent of the government. So if you complain to us, we're not coming from your side. We're not coming from the public body side. Really, we're looking at all the information available to us and trying to come up with an independent decision. And it would be largely evidence-based. We're an alternative to the legal route, and we're free, which is really good for people to know, I think. And one of our primary aims is to raise the standards of public service and to ensure ongoing improvements. Sorry. As I said before, we focus on administrative actions. We can't look at clinical judgment. We can't look at academic judgment. So if you've been in hospital and you feel you've got the wrong diagnosis, you've been prescribed the wrong medication, we wouldn't be able to look at that. The relevant bodies for that would generally be the Medical Council or the Nursing and Midwifery Board. Similarly, academic judgment, we do deal with complaints about education, but if you feel that your course, the content in your course was not the correct content, or you were marked unfairly in an exam, now we could look at the marking system, but we couldn't look at whether you gave the right or wrong answer. That would be academic judgment. We can make recommendations. They're not legally binding, but we find that generally our recommendations are accepted by bodies. It's very rare that they're not. If we do have an issue, we can make a report to the Oireachtas, but generally we have a good working relationship with the bodies, and we managed to come to an arrangement in a non-adversarial manner, which is one of the benefits of the system. We have the power to obtain any file or document under Section 7 of our legislation. We can request any medical files, social welfare records, anything like that once we have your consent. And if we don't receive that from the body when we request it, then we can actually, under our legislation, compel officials to appear before the Ombudsman. So it's up to the Ombudsman himself how he decides to investigate a matter. So if he feels someone had to appear before our office or interviews were required, we could do that, or we can request the files. It depends really. Who cannot complain? So as I said, you've to have been unfairly treated because of an administrative action by a public service body. We do take complaints from representatives. So if someone does not have the capacity themselves to make the complaint, or is finding it too emotionally stressful, or just does not have, say, the literacy skills, then we're more than happy to take a complaint from a representative if we have the consent of the person, and we would usually request written consent. As I said, you have to have been adversely affected. So if you're complaining about, sometimes in relation to planning or something, a tree that's been planted, if it's not anywhere near you, you're not adversely affected, directly adversely affected, then we may not follow up. And this is really important. You need to complain or appeal to the public body, service body first. So you first have to have gone through their complaint system and made reasonable efforts with them to try resolve your complaint. You must not have initiated legal action. So if you've gone to court on the matter, we wouldn't get involved. Or if you initiated proceedings whilst your complaint was open to us, then we would withdraw. And your complaint has to have been made within 12 months. Now that 12 months is either of the issue happening or 12 months from the time that the complaints process within the public service body is completed. So you may have become aware of the issue and then gone through a lengthy complaints process with the public service body. It's 12 months from when that finished, as opposed to 12 months when the issue originally arose. But if it's outside those 12 months, we generally wouldn't accept them because it becomes much more difficult to investigate. How to complain? You can go on to www.ombudsman.ie. We're based in 6 Earlsfort Terrace, Dublin 22. Dublin 2, you're welcome to call in. We hold monthly complaint clinics, so we go out to the CIC Galway, the CIC Limerick. We try to do kind of a little bit of outreach to reach people that would find it more difficult maybe to reach us. Also, we have an access officer, and that information is available on our website. So if there's any accessibility issues, then you're more than welcome to contact Peter Mahoney, who would be our access officer, and he should be able to help you. So as I said, our approach to complaints is informal. It's non-adversarial. We try to do it in the least stressful way for everyone, both you, the public body, and try to come up with a solution that makes everyone happy. Speedy resolutions. We really try to do our best to complete complaints within the fastest time possible. With complex complaints, that can be difficult. They can take time. There can be a lot of to and froing with public bodies, and I think it's important for people to understand that it won't be a quick fix, but we do try to resolve them in the shortest possible time period. We do a detailed investigation if necessary, so matters can be escalated within our office. We have an early resolutions unit. I have a slide somewhere. I'll go looking for it. But things start off with the early resolutions unit and then filter into investigations if they're more complex. We identify systemic issues, so if something's coming up again and again and again, then we have the power to address it on a more macro level. We can go to the department and saying, look, we're noticing this is a trend, and try, instead of dealing with each individual complaint, try deal with it on a broader level. And a big part of our job is highlighting learning to prevent reoccurrence. So we don't want to just get a sorry, this shouldn't have happened. We always go back and say, well, what improvements have you put in place? What measures are you taking to ensure that this doesn't happen again? So common complaints, poor communication, that comes up again in every single sector, to be honest. An unreasonable delay with response. So you may have written your apology, or your complaint, sorry, may not have been acknowledged, or the substantive issue may be taking ages to investigate, and you haven't been told there's delays. There may be a failure to explain the reason for a refusal to deal with your complaint. Poor treatment, denial of an entitlement. You may feel you're entitled to, say, for example, social welfare payment. You've been denied that. We deal with them. And then unfair assessment, complaints complaints and appeals procedures. Basic, we're looking at anything where people feel they've not been treated fairly and in line with fair procedure. As I said, our aim is to put the person back into the position he or she would have been if the public body had acted properly in the first instance. So say in relation to something like a social welfare benefit, if you had been refused it inappropriately and you should have received a social welfare benefit, then we would have we would ask that that be backdated to when you should have received it. And we would always ask for recognition that something had gone wrong and an apology. And we'd have quite strong feelings on apologies, and would have guidance on our website in that it would need to be a meaningful apology. So not just, I'm sorry that you feel this way, but an actual acknowledgement that something went wrong, and an explanation perhaps of why it went wrong and what they're doing to prevent it happening again. These are the slides I was looking for. So in 2022, we had 4,791 complaints received, which is quite a high number. And you'll see the breakdown here. So the largest amount were government departments and offices with 1,842, 1,269 from local authorities. After that would be the health sector with 790. Regulatory bodies, so we deal with the Legal Services Regulatory Authority, CORU, basically any of the regulatory bodies, 273 other bodies, 164 education sector. So that would be the various colleges, maybe SUSI, the grant scheme would fall within that. 67 private nursing homes, 59 direct provision. And pre-COVID, we were going out, and that I don't know if it started again, but we'll be starting again, if not where we go out to the actual direct provision centres. And then, as I said earlier, it's quite a small amount, but 14 under the Disability Act. As I said, we also do investigations, and we would have done one into direct provision, or no, non-investigation, sorry. We produced reports, and we would have done a report into direct provision and provided an update on the work we've done. We would have a report on fair recovery, which is our investigation into the Department of Social Protection and how they managed overpayments, the Magdalen Restorative Justice Scheme, and then learning to get better. That dealt with hospital complaints, a good death, end of life care. And then particularly relevant to the disability sector, as I said, I was lead investigator on wasted lives, which was a report into under 65s in nursing homes, and grounded, which was a report into unequal access for people with disabilities to personal transport schemes. So grounded would have dealt with the motorised transport grant, the mobility allowance scheme, and the disabled drivers and disabled passenger scheme, and the disabled drivers medical board of appeal. And I'm sure you're even more familiar than me the issues with these schemes. We would have done a number of investigations over the years and would have put forward proposals and recommendations. And the response in the large part was just to halt the schemes, which is not ideal. The Ombudsman feels very strongly about this. He doesn't feel the response has been good enough. And in our annual report last week, he would have said again that progress in this particular area is just not good enough. And I think on the same day, Leo Varadkar would have announced that he agreed that progress in these areas is not fast enough, and that he's going to be convening a meeting in relation to same. So we'll keep pushing this issue, and hopefully improvements will come, but we are very conscious about the deficits in this particular arena. Just going to give 3 very quick case studies. This is someone who applied for back to education allowance, and you need to have a qualifying payment at the time. They'd applied for carers allowance, which was a qualifying payment, but there was a delay in their carers allowance being approved. And once it was approved, they applied for retrospective back to education allowance because they couldn't apply for it at the time because the delays in their carers allowance, and that was refused. So we became involved, and we said, look, if there hadn't been delays, they would have had their carers allowance and they would have qualified for back to education allowance, and really in line with fair process, they should have been granted a retrospective back to education allowance. So after our intervention, that payment was awarded. And then no access to hospital and medical records at the weekend. So someone had a procedure on the Thursday, and then they had to attend the emergency department on the Saturday. And when they went into the emergency department, there were no medical records available, because after the procedure on Thursday, the records had been sent for coding to the hospital inpatient inquiry department. We said that's not good enough. You have to have a system in place whereby healthcare records are accessible whenever they're needed to ensure quality of care. So as an outcome, the hospital introduced new protocols. It undertook an audit to test the accessibility of healthcare records to clinicians out of hours and at weekends, and that will hopefully prevent that problem arising again. And then I just thought I'd put one in about the Disability Act, just to kind of give a sense of what we can look at. So this particular lady made a complaint to us under the Disability Act. She'd been invited by a local candidate to attend a local election count. And the county council refused her request for a sign language interpreter to be present on the day of the count. They said there'd be sufficient signage and screens at the count centre to enable her to view the count on the day. However, she said this was inadequate as the lighting was poor. The screens were too far away and they often appeared blank and there was no signage available. So they, as I said, they refused her request. The lady came to us and argued that they'd failed to comply with the code. And we agreed. We feel they'd failed to comply with the code and therefore failed to comply with two provisions of Part 3 of the Disability Act as amended, namely access to services and access to information. And the council accepted that it should have had arrangements in place for the provision of an Irish sign language interpreter in the future if one is requested. So I'm sorry, this has all been very fast. There's a lot to squeeze in. A quick summary. Who can you complain about? So government departments, HSE, local authority, education bodies, a really broad remit, and our list is on our website at ombudsman.ie. Before submitting a complaint to the Ombudsman, it's really important that you've tried to resolve the issue with the public body first. We can't accept complaints unless that's been done. When providing a complaint to us, it's really helpful if you're clear in your complaint. So really what we want to know is what your complaint is about, what the adverse effect is, so how it's affected you, what the problem is, and then really what you want us to achieve. And I think it's really important then as well that we have that discussion with you early on in the process, what we can do and perhaps what the outcome can be, and just to reiterate again that we're impartial. So if you want to contact us, you can go to www.ombudsman.ie or call 01639 5600. As I said, we have an access officer who would more than happy to help if that's required, and NCBI will have my email address, so I'm happy to answer any specific queries if that's of benefit. So that's it. Liz?
Thank you so much, AnnMarie.
Sorry, it was a whirlwind.
That was you presented beautifully, and you explained it all very logically and very rationally. A couple of questions, both on an individual level and then a much broader level. If it's the individual person who's making the complaint, you mentioned that they need to have made an attempt with the public body to have resolved that complaint. What kind of evidence do they need to show you that that's actually happened?
If you've made a formal complaint, you should have a formal written response generally. Sometimes we come across where someone has had a meeting and we kind of accept that and we go back to the body and say, where is the minutes of the meeting? But generally, like if you make a complaint to your service, you're saying with the health HSE, there's certain process, you should have a report at the end of that process if it's a significant complaint. So they have their own policy. Every public service provider should have their own complaints policy. Everyone has the right to request a copy of that complaints policy. And I actually think if you have a complaint, that's always very helpful for yourself to have. And then they will have certain steps in place within their complaints policy. So you should generally, if you've made a complaint, you should have something at the end of the process that you can provide as evidence. But if you feel you've made a complaint and you've come to the end of the process and you don't have that written evidence, we'll have a chat. You know, we're not shutting things down. We'll figure out why you haven't had it, or, you know, establish if the process is finished or if it's premature to us. Does that make sense?
Yes, I did. So are you saying then, AnnMarie, that it might be worthwhile people asking for the organisation, the public body's complaint process information as they start this? The reason I'm asking is that often they might initially try and make a phone call, it's not returned, and they actually don't have anything tangible to say.
So again, and apologies for using the same example, but it's the one personally I'm most familiar with in my casework. Say both the health service executive and TUSLA would have their TELUS policy, the health service executive would have your service your say. The policies are quite similar, and there are different stages of reports. So stage 1 will be local resolution. It's that kind of idea. If you're in the hospital and you're annoyed with something, that you approach someone and they try deal with the complaint there and then. And then you'll have stage 2, where you have a complaints officer allocated to you. And then maybe stage 3 is you may be offered a review of your complaint by the hospital group, and then we'd be stage 4. So there's most complaints policies have quite a structure set out in them, that allow for that informal process at the beginning. But if you feel you're not getting anything from that, you can escalate your complaint. Now, personally, I would suggest that is helpful. If you're somewhere at the time, if you're in a social welfare office and you feel you're not being treated fairly, you can ask to speak to someone. But if you go on to the next stage, it's always good to have things in writing, for yourself, that you can say, look, I sent this on this date, and we don't demand this, you have to, but it's useful generally in complaint management, I think, to have a paper trail. If possible, just for yourself. It makes your own life much easier when making complaint, when you can say, I sent this on such and such date. Whereas with phone calls and in person, they're harder to say, look, I did this, and the body can go back on, we've no record. But there is provision for that usually in the initial stages. But I would say try do that at stage 1. Try resolve it locally. It's less stressful for everyone. But if it's not, then put your complaint in writing. That's generally what I would advise, if that helps.
Absolutely, it does. Thank you, AnnMarie. With regard to all this information that's being exchanged, a question that might come up for a lot of people: what aspect of confidentiality is involved here of all this swapping of information? So
in respect of our office, we generally would ask for your consent unless there's implied consent in your complaint about accessing your information. We would deal with very sensitive information. Like anybody, we would abide by the principles of GDPR, which would be that we would only request the information that is required for the investigation of your complaint. So again, excuse the specific example, but it's the area I'm most familiar with. If you complain about a particular medical issue, a particular clinical issue or appointment or an inpatient stay, I'm not going to ask for all your medical records since you were born. I will just ask for that particular stay or what I need to investigate your complaint. So we abide by those kind of, the general GDPR principles. And then in terms of confidentiality, well, we wouldn't be sharing that information with anyone. And if we are dealing with a representative, we would have to have, so say, it may be a family member, may be acting on someone's behalf, or it may be a TD, it may be someone like yourself, Liz, even, it may be an advocate. We would need written consent for the person if they have capacity. And we would be very mindful of the new assisted decision-making capacity legislation in that regard. But your information in our office would be treated with confidentiality, and we would only request the information that we need. Do you have a specific example, or does that kind of cover what you're asking?
No, that's fine. Thank you, AnnMarie. I think people are very wary. They're always wondering where the information goes, especially if it might be very sensitive information. You mentioned the hospital system of people having complaints within hospital systems.
Yeah.
So I guess I just wanted everyone to hear from you. How serious you take that information that's exchanged with you.
We'd be very conscious of that, and I mean, even the amount of training on GDPR, FOI, data protect, it's a big, and like more than anything else, aside from all the legislation, aside from anything else, it's more that we're conscious that you are giving us this and how difficult this is, and that this is your personal information. So we want to be respectful, and we always strive to do that. But your information is treated appropriately always. And again, if you feel that's not the case, there are avenues to pursue in terms of our data protection officer, etc. But that generally, I would hope, is not an issue.
All right, great. Thank you. The average person making a complaint might wonder, just how academic it has to be when can they ring you? Can somebody help them through the terminology and how to phrase it, or they don't need to write a whole submission for this? Can you describe a little bit about how much information and how it needs to be written or couched when somebody calls you, or does it online, or what's available?
Firstly, we'd be strong advocates of plain English and would actually be critical of bodies that use jargon. That's not, it's not ideal in the complaints process. We would advocate that people use language that people understand, otherwise it defeats the whole purpose. And we would try to do that ourselves in our letters. So that's one part. In relation to making a complaint, you can go online. And a lot of our work now, we're kind of streaming it that way, and you can go online and you could submit your complaint and there would be various sections to fill out. But we still, not everybody has either the literacy or even the access to the internet. So we still take written complaints. You can still pick up the phone and call, especially if there's an accessibility issue in terms of literacy. That's kind of where our access officer would come in. We're trying to facilitate people, we're not trying to put up hurdles. So, and in terms of submissions, we don't need anything complex. And actually, the more clear you are and the more concise you are, the easier it is to deal with a complaint. Sometimes we get very lengthy complaints and really you have to distill them down to what the actual issues are. So there's definitely no need for a dissertation. It's better for everyone to be just clear and concise, plain English, just what you feel went wrong, how it's impacted you, and what you want out of the process. Those are the three main points, to be honest. And once you cover them, and a little bit of background is always helpful. But yeah, it's nothing too arduous, and we will work with you. If we feel we don't have enough information, we'll go back to you. And personally, when I accept a complaint, I always write to the person summarising their complaint to make sure that I have it understood correctly, so that at the beginning of the process, we're both starting off on the same page instead of getting down the road and they're like, that's not what I was complaining about. So, it's wrong to say partnership because we're impartial, but we work with you in terms of establishing what your complaint is.
Fantastic. I'm sure everyone's very heartened to hear that you have the keep it simple principle of people confirming with each other at the beginning of the complaint that they've understood what happened. On a bigger picture, I was interested to hear you saying that only 14 complaints were received from about disability issues. And I was wondering what your interpretation of that would be, what your assessment might be of why.
The person who heads up that is called Michaela Benassi, and she's probably better able to answer that, and you're welcome to contact her. I think it's hard because you could assume that everything's working perfectly, or you could assume that people don't know they can complain. I'm not entirely sure why. I think it's come up since last year, so it's a work in progress, to be honest. And I think events like this, highlighting that you can complain under the Disability Act is very helpful in kind of clarifying our role. I think our role is quite specific as well, in that we're looking at compliance with the Act as opposed to investigating the particular issue. But again, there will be a whole section on that on our website if anyone has any queries. But I think that example of the lady, the sign language interpreter, is quite a good example. But a lot of the complaints, my understanding is a lot of complaints about accessibility relate to footpaths, or under the Disability Act relate to accessibility and footpaths. And we're just looking at whether the relevant council has allocation inquiry officer and looked at the matter. as opposed to us looking at the substantive issue, if that makes sense.
And you'd be interested to know, AnnMarie, that NCBI runs a campaign, a week-long campaign every year coming up in August called Clear Our Paths. So you're absolutely right. It's a major issue, isn't it, of the overhanging branches, cars parked on footpaths, dog poo everywhere. So it's especially with the new electric scooters aren't helping.
I've had the fortune of having to use a buggy, a baby buggy, in the past 2 years for the first time, and that's really been an education on. I would have been mindful of any of it because I've particular interest in disability issues, but I think it really hones your mind when you. I mean, a buggy is much easier to manage than any of the other reasons why you would need to clear a footpath. But yeah, I've become much more aware of cars on footpaths since then. But yeah, no, I'm aware of that day, and I always do my best to push it. It's important.
Especially when you have to take your buggy out onto the road and go around.
Well, not the buggy so much, but like I know people in wheelchairs, and I just
So
it's the same if you're using. I've again a friend using a guide dog or a stick, anything like that is an impediment to.
It's absolutely wonderful to hear that your brief. Your scope has been widened. You mentioned very early this afternoon ever widening, and that you've really explained well, I feel, today about exactly what public bodies is and even the ones that get funding. So that would include charities like NCBI, I'd imagine, because we get public funding. We could be complained against by, if somebody wanted to bring a complaint.
I don't have my list in front of me to check NCBI, but so basically, I don't know if you're familiar with Section 38 and 39 bodies.
Yes.
So Section 38 and 39 bodies are bodies that receive a certain amount of funding from the Health Service Executive or other, and those fall under our remit, yes.
So yes, so that, I think a lot of people might not see, the public side of a body like all the charities and other types of organizations. So it might be worth, if they're not sure, to give you a call and check it out in the first instance.
Yeah, definitely. If you've queries, phone us. And now we might have to go look and find, because as I'm sure you're aware, the list of Section 39 bodies.
Yes.
Is extremely long, and sometimes we have to look at where the funding comes from. But no, if you've complained about someone, we'll always phone us and we'll check if it's in remit. That's not a problem. But remember to complain to the body first. That's the most important thing.
I guess the checking might be to find out whether, if a complaint was needed down the track, it was starting to move in that way, whether you would be the appropriate body to take it to. Or whether the person might need to take it elsewhere if it didn't come under your scope, sort of thing. So I
guess the ones that kind of often fall out of scope would be those clinical judgment issues, or matters relating to education. If someone's under 18, if the primary adverse effect is on a child, that would be the Ombudsman for Children. Like I said, GSOC would be about the Gardaí. So those kind of those issues wouldn't be for us. And sometimes clinical judgment, it may not at first appear to be clinical judgment, but it may be clinical judgment. So sometimes with waiting lists, we can look at how they're managed, but at the end of the day, it may be clinical judgment that informs where somebody is put on a waiting list, and we can't question that, if that makes sense. And similarly with some of the welfare payments, we wouldn't be questioning the decision of, say, the CMO in terms of a medical condition. So
it's all accessible at the very beginning. You would work out whether it was within your jurisdiction or not.
That would be at the very initial stages. You should, you wouldn't be months into complaint. Now sometimes if you have a complex complaint that's multifactorial, you might be kind of into the complaint and discover some of it may be to do with clinical judgment, but like the basic ones should be established at a very early stage, and when you send your complaint in, you get an email back kind of just clarifying what we can look at again, a standard email that explains all that.
You just answered my final question. I was going to ask you what happens if, when there's multiple bodies involved in something, which there often is, And some of those might be within your scope and some might not be. Would you engage with the other bodies, or would you simply deal with the area that relates to your responsibilities?
We can only deal with what's under remit under our legislation. So if it's something that's not within remit, we wouldn't be able. So say, for example, you have a complaint and it involves the Gardaí and it involves TUSLA and it involves a hospital. We can look at TUSLA and the hospital, but we can't look at the element pertaining to the Gardaí. And then even within TUSLA and the hospital, we wouldn't be able to look at the clinical judgment element. So all that is kind of filtered out. If you've a complaint about that, again, as you rightly said, and this often happens, which is it relates to a number of bodies, really what you'd have to do is pursue and when I'm saying this, I appreciate how difficult this is and how stressful it is, but really you'd have to complain to each body individually, and then you'd have to complain to our office, but you'd have separate complaints for each body, if that makes sense.
Yeah. Well, even though that sounds very arduous, I think it's good for people to know that the very fact you could only look at parts of it, it wouldn't be just counted all together. You would still be willing to look at the part that involves your responsibility.
Of course, like we often get complaints where there are bits we can't look at. And again, clinical judgment is a really good example, because you can get a really lengthy complaint and you'll pick out what's clinical judgment, but there'll be loads of administrative issues in relation to communication, record keeping, etc., that you can look at. And we definitely look at them every day, and we have a large volume of it. So, I mean, it wouldn't be uncommon that we'd have to pick out what we can look at. But I mean, we'll be very open with you and we'll go through that and we'll explain that. You know, it sounds complex. It's hard dealing with complaints because often the initial issue that you're complaining can be emotive or upsetting, and then you're going through a complaints process with the public service body, which again can be stressful. Then if you're coming to us, it means you're not happy with the outcome of that, which is upsetting, and then you're coming to us and going through another process. So we're very conscious that it's not easy for people. We don't want to make your life more difficult. You know, we're here to help you. So I think it's important to say that you know, we're not trying to make things difficult, but we do have certain things that we have to do to ensure that the complaint is within remit. There are things we can't look at under legislation, but overall, like, our job is to deal with complaints, and that's what we do. So and I mean, it as stressful as it is free, and it is possibly less stressful, I would hope, than the legal system. So there are pros and cons to everything.
And I think what you've explained, AnnMarie, about how transparent you are, and to clarify those things at the beginning of the process with people is very heartening for people. They know where they stand. You know, they're not, you know, exactly. You're clarifying the issue, but you're also clarifying what you can and can't do. And I think that honesty is often what isn't apparent and available in the complaint processes that people have come from.
I would hope that the presentation is like it can be complex, but it's not that complex. Like, we can't deal with the guards, we can't deal with, you know, we have it on our website. There are certain things we just can't look at. Now, sometimes it can be hard for people to understand that, but unfortunately, like, we have to act within the limits of the legislation. So it's not within our powers to have any flexibility in that regard. If it's not within remit, we can't look at it. And unfortunately, that's how it is. But often there's other avenues, and if we know another avenue, we will direct you to that other avenue. You know what I mean? Like, if someone comes to us with complaints about the Gardaí, I think we would probably be directing them to GSOC.
Yes.
So the hope is we try to have a holistic complaints process, you know, where there's no wrong door for anyone, but it's a complex system at times. I appreciate that.
Well, I think it'll be very heartening also for people to hear that, you know, they have that guidance in taking it, and people like yourselves taking them through this whole process. And the very fact that you exist, you know, the Ombudsman isn't some high hierarchical play that isn't for the ordinary everyday person. It is for the ordinary everyday person to lift the phone and say, I've tried to resolve a complaint with so-and-so. Is this something you can help me with?
Yeah, and you know, if it's premature to us, we'll explain it's premature and we'll tell you, look, you have to finish this process, and then it's open for you to come back to us. So just because we say you can't come to us yet doesn't mean you can't come to us. So you know, all these things are worked out. I just, if you feel you've been treated unfairly by the public body, you do have us as an avenue, and I think that's the important thing for people to know.
That is an excellent way to finish, AnnMarie. You said it all in one sentence. Thank you so much.
No problem. And
you summed it up beautifully. I just want to thank you on behalf of everybody that's listening.
No problem.
And this recording will go up on NCBI's YouTube channel on our website. And I would really encourage everyone to listen, and also perhaps to access the Ombudsman's website, particularly the grounded report that AnnMarie referred to. I think will be a great interest to everyone. And it's great to know you're out there, AnnMarie, and thank you so much for joining us today.
Just to say, I haven't put my personal email up because I can't take individual complaints. They have to go through the system, and but if anyone has a query or a general query, Liz, you've my email. Like, I'm more than happy for anyone to contact me. I just didn't put it up because I didn't want to take individual complaints.
No, fair enough.
I can take,
no, that's fine.
I'm always happy for someone to pick up the phone if they have a query and see what I can do. And if I don't know the answer, hopefully I'll be able to find the person that does. And like I said, Michaela deals with Disability Act complaints, so she's a wealth of information in that regard.
Fantastic. Thank you so much, AnnMarie.
No problem. Thanks for having us.